everyone. On behalf of the Rockefeller Center, welcome to tonight's event. To those of you who are looking forward to an in-person event, our apologies. But we are so grateful that our accommodating colleagues and amazing technology have allowed us to bring you this event virtually. Before we get started, a couple of Zoom housekeeping details. You can ask your questions at any time during the event by using the Q&A button, and asking your question early increases the likelihood that it will get answered. And if you are in need of the closed captioning, navigate to the live transcript button and select show subtitles. If you don't see that option, look under the more button and you should find it there. It is now my great pleasure to introduce our host for the evening, Associate Professor of Government at Dartmouth, Julie Rose. Thank you.
Thanks, Joanne. Hello, I'm delighted to be with everyone here today and to welcome you to this year's William H. Timbers Lecture. Thank you, everyone, for joining us. So today's Timbers Lecture is sponsored by the Nelson A. Rockefeller Center for Public Policy, and it's part of the Legal Studies Speaker Series for the year. I wanted to thank Bob Coates and Joanne Blay in particular, and Herschel Nachlass, who's co-convener of this year's speaker series, for bringing this whole event together and for making some last-minute adjustments as well. The Timbers Lecture was endowed in memory of the Honorable William Timbers, class of 1937, who was a U.S. District Court and Court of Appeals judge. We've been fortunate to have an esteemed list of past Timbers lecturers, including most recently Lee Epstein, and in prior years, Tanya Hernandez, Pamela Carlin, Will Kimlicka, Catherine McKinnon, Linda Greenhouse, and Martha Nussbaum. And we're honored to have, and will be lucky over the coming years, to be able to include her name among this list of esteemed past speakers of the Timbers Lecture. So we're really honored to have Professor Sonali Chakravarti here with us today to give this year's Timbers Lecture. Professor Chakravarti is a professor of government at Wesleyan University, where she examines issues of citizenship, law, and democracy. She's the author of two books, Sing the Rage, Listening to Anger After Mass Violence, and connected to the subject of her talk today, Radical Enfranchisement in the Jury Room and Public Life, which I really recommend to everyone. Also has a wonderful cover. Her recent work on juries has generated rich output in academic publications with articles entitled Wanted, Angela Davis and a Jury of Her Peers, and The Necessity to Nullify the Jury and Entrapment, among others. But Professor Chakravarti has also done the important yet often challenging work of broadening the reach of her scholarship by writing about issues of race and racism in the jury process for outlets such as the Boston Review, The Nation, and The Guardian, enriching public discussions of the legal processes to seek justice for George Floyd and Ahmaud Arbery. The Timbers Lectures are devoted to the study of law and justice, and Professor Chakravarti's talk today will, like her work, illuminate our understanding of these ideas with her really rich insight. The title of her talk today is How Woke Can a Juror Be? The Jury in the Chauvin Trial, Critiques of Law Enforcement, and a New Model of Impartiality. With that, I'll turn it over to Professor Chakravarti. Thanks so much for being with us today and for your sharing your work and your insight with us. We really appreciate it.
Thanks, Julie. I'm very happy to be here, and I really appreciate the work that you have done, and Joanne, especially today, in the quick switch to virtual programming. It's an honor to be in such esteemed company with the list of previous Timbers lecturers. So the title of my talk today is How Woke Can a Juror Be? The Jury in the Chauvin Trial, Critiques of Law Enforcement, and a New Model of Impartiality. On May 29, 2020, George Floyd was detained by the Minneapolis Police Department for allegedly passing a counterfeit $20 bill at the Cup Foods. He said he was claustrophobic and did not want to be transported to the station in the police car. When the officers allowed him to sit on the ground, handcuffed next to the squad car, he expressed appreciation for the accommodation. What happened next was recorded on a cell phone and became the impetus for the largest civil rights demonstration since the 1960s. The video showing George Floyd's death under the knee of police officer Derek Chauvin was shocking even to those who were well aware of the history of police violence in the US because of the apparent callousness of Derek Chauvin and the other officers involved. The Black Lives Matter protests that had been occurring in the United States since the 2014 death of Michael Brown primed many of the people going to Cup Foods that day to stop and take notice of what was going on. Many tried to intervene. The footage of Floyd's death led to mass demonstrations in the Twin Cities, then the rest of the US, and then the world. All 50 states would eventually hold protests calling for accountability in the case. An estimated 15 to 20 million people participated in the demonstrations, including over 500,000 on one Saturday in June of 2020. Polls showed that the number of Americans in support of Black Lives Matter grew to record highs, largely driven by increased support from white Americans. For example, a Pew Research Group poll taken in September of 2020 showed that 55% of Americans felt favorably toward the Black Lives Matter movement. As a scholar of juries, I was interested to see how this change in perspective about police violence and patterns of racial discrimination might play out in the courtroom. In the past, criticisms of law enforcement or support for Black Lives Matter have been the basis for jurors, particularly Black jurors, being dismissed from jury service. In December of 2020, hundreds of residents in Hennepin County were sent questionnaires informing them that they were potential jurors in the state of Minnesota versus Derek Chauvin. And here are some examples from the 14-page questionnaire that they were sent. So you can see from some of the questions that it was assumed that the jurors had seen the video, and the judge in this case, Peter Cahill, made the choice not to move the trial outside of downtown Minneapolis, knowing that most people would have some familiarity with the case, but what he wanted to do was see what that familiarity led them to and whether they would truly be open to the evidence in the case and to both verdicts. So every juror that was seated was open to both a guilty or not guilty verdict. I was particularly interested in question 4. Did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place after George Floyd's death? If you participated, did you carry a sign? What did the sign say? And I was interested because by asking if some people carried a sign, I wondered whether the judge and the attorneys would be open to people who had participated and to show their outrage and their sense that police violence was a problem, but that they would also be able to take their responsibilities as a juror seriously. Here are some other questions that came up in the questionnaire, and you can see that there were wide-ranging questions about racial discrimination, including, do you think that Blacks and other minorities do not receive equal treatment as whites in the criminal justice system? Do you think that local police try to cover up excessive force rather than correct it? Do you support Blue Lives Matter? So the questionnaire wasn't just asking about Black Lives Matter as a movement, but was really probing understandings of patterns of racial discrimination in the United States. The last question is also extremely important. No matter what you have heard or seen about this case, and no matter what opinions you might have formed, can you put all of that aside and decide this case only on the evidence you receive in court, and then decide the case in a fair and impartial manner? This last question was part of a series which enumerated the constitutional protections to which the defendant is entitled, including the right to remain silent, the right to not present evidence, and the right to have an impartial jury free of prejudice and bias. I will argue that this questionnaire reflects the possibility of a new contextual understanding of impartiality as the ability to balance candor about the history of racial discrimination in the legal system on one hand, with the responsibility to give each defendant a fair trial. This new understanding of impartiality, for this new understanding of impartiality to work as a standard, it is important for jurors to have the chance, both in the survey and in voir dire, that is the interview portion of jury selection, to affirm their understanding of the proper expectations of jurors in a trial and reduce the possibility that an attorney may infer an inability to be impartial or an unwillingness to grant the defendant the presumption of innocence based on a juror's political affiliation, manner of speaking, dress, or any other factor. If a juror is to be evaluated on her ability to abide by the expectations of the criminal process, she should be asked direct questions about the criminal process. And this last one is one example of that. This is what occurred in the trial of the state of Minnesota versus Derek Chauvin under State Court Judge Peter Cahill. For 3 weeks last March, I was able to watch the live stream of the jury selection process. While I couldn't see their faces, it was fascinating to listen to juror after juror grappling with how to understand the video of George Floyd's death, their responses to Black Lives Matter, and their understanding of racism in the criminal legal system and society at large. There were several moments when I was sure a juror would be dismissed by the judge or by the attorneys because they did not fit the textbook example of a superficially neutral and uninformed juror, but I was wrong. Voir dire in the Chauvin trial produced a jury that was unexpectedly more racially diverse than Hennepin County, the county where the crime and trial took place. So what we got was a jury of 14, 12 plus 2 alternates, of 4 identified as Black, 2 as mixed race or multiracial, 8 identified as white, were 9 women, 5 men. 13 said they had a somewhat favorable or very favorable impression of Black Lives Matter, and 1 was neutral. The trial was watched by many more people than had been anticipated. Many Americans followed the testimony of witnesses closely, including the testimony of bystanders who gathered on the street, medical professionals, and police officers who spoke about the use of force training officers it received. It was unusual to have the chief of police testifying against another police officer. On April 20th, 2021, the jury found Chauvin guilty on all counts of murder and manslaughter. He was later sentenced to 22 years in prison. So today I will argue that in normalizing the language of the critique of law enforcement during jury selection in the 2021 trial of Derek Chauvin, 3 important changes occurred. The first was that Black jurors were less likely to be dismissed for opinions they have long voiced, but which had been seen as the basis for legitimate dismissal. The second was that it clarified what the standard of impartiality should mean for the court, given widespread scrutiny of the racial discrimination within and outside of the law. And lastly, the topics covered during voir dire serve to highlight precisely the types of life experiences that may be valuable for the juror's task of phronesis, Aristotle's term for practical wisdom, necessary for deliberation and the verdict. The jury selection process begins with citizens receiving a summons, sometimes along with a questionnaire specific to the case, usually because their name has been drawn from either the list of registered voters or from their driver's license. Scholars have long pointed out that the reliance on motor voter lists systematically excludes jurors of color who are less likely to vote and more likely to rent rather than own homes, and therefore more likely to change permanent addresses. Thus, the disproportionately lower number of Black potential jurors begins at the first stage of the process and continues through each subsequent one. Once they are part of the panel, jurors are asked to report to the courthouse to determine whether they're eligible to serve. Jurors must be US citizens, 18 years old, and able to follow a trial conducted in English. Next, the judge will swear in jurors and ask them questions to determine whether they can fulfill the responsibilities during the trial. At this point, jurors may be dismissed in 2 ways. The first, the dismissal for cause, occurs when the judge determines that the jury has a close connection to the parties in the case or is otherwise unable to be impartial and consider the evidence in a fair manner. Both sides are able to petition for dismissals for cause, or the trial judge may act alone. The second way is known as the Peremptory Strike, and this occurs when one side chooses to use one of their limited number of strikes to dismiss a potential juror who has already been declared qualified by the judge. Counsel does not have to provide a reason for the strike, but it cannot be based on discriminatory intent on the basis of race, gender, or sex. If one side suspects discrimination with a specific peremptory strike, they may raise a Batson challenge, requesting that the judge investigate whether the peremptory strike was proper or not. Based on the 1986 finding in Batson v. Kentucky, the Supreme Court laid out an analytical framework whereby counsel may argue that the opposing side's strike is rooted in racial discrimination. Then the attorney who exercised the strike must give a reason, and then the judge has to determine ultimately whether purposeful discrimination by the attorney occurred and led to an improper dismissal. If the judge finds a strike to be improper, the usual remedy is that the juror is seated or an entirely new jury is assembled. Given that judges are predisposed to trusting attorneys and there is a wide latitude available for peremptory strikes, Batson challenges are notoriously difficult to win. It is not difficult for an attorney to come up with or fabricate a race-neutral reason why they didn't like a juror and make this the basis for a peremptory strike. Judges want to give attorneys their fair share of peremptory strikes, and so they tend to believe them. Those cynical of more open discussion during voir dire might point out that asking Black jurors to spell out how they perceive racial discrimination in the media or their thoughts on Black Lives Matter might give fodder for legitimate peremptory strikes that will result in the same racially lopsided juries that we've seen in this country. In some ways, this is true. Yet, I am arguing that more open discussion of critiques of racial discrimination and law enforcement will make it harder to pinpoint Black jurors for mistrust when there are other jurors who articulate similar opinions, a dynamic that we saw in the Chauvin trial. The Sixth Amendment protects the right of the accused person to a speedy and public trial by an impartial jury. The founders were adamant that the jury must be protected as a local check on tyranny in all its forms, including federal power and the overreach of the law. While in the Middle Ages, jurors were often eyewitnesses with firsthand knowledge of the case, the current meaning of impartiality emerged after the move to separate witnesses from jurors. The ideal juror emerged as someone who was far removed from the case, having no personal investment in the outcome, and who was able to evaluate the evidence without prejudice or passion. While logical deduction and replicability are valuable in the legal system writ large, the one-off nature of jury decisions is a recognition of the importance of three key aspects of juries. The first is that the particular circumstances of every case are important. No case can be summarily categorized and adjudicated without protections for the defendant best achieved in a trial. Second, there is a danger to leaving the administration of justice to repeat players in the legal system whose livelihood depends on the outcomes of cases. And lastly, the court values jurors' lived experiences, including their observations about the practices of law enforcement, and this is necessary for the legitimacy of the verdict. It's for these reasons that the founders saw the value of juries in the colonies before independence and why protections for the jury in criminal and civil cases were included in the Constitution. For Aristotle, legal judgments require a type of phronesis, his term for practical wisdom, and this is in contrast to the scientific knowledge or technical knowledge that characterizes other forms of applied cognition. Phronesis cannot develop through abstraction. It requires a fluid understanding of the intrinsic goals of the activity in which one is engaged and an appreciation of its standards of excellence and the particular ways in which an outcome might fall short. As a juror, this means an awareness of the ideals of the criminal trial, including protections for the defendant, as well as the value of fairness, universalizability, and mercy, among others. Jurors must understand that the application of the law cannot be done in a formulaic or techno-rationalistic manner. Part of the value of the jury system is that jurors bring an element of experiential knowledge and attention to the conditions of life in a particular geographical area. If this lived experience were not so critical to jury service, there would not be the expectation of vicinage and residency. The particularity of one's life experiences matter in this realm of knowledge. The task of judgment does not require contorting oneself into a place where one claims to have no prejudices, but a juror must be open to experiencing the features of a trial that serve to mitigate its impact and guide jurors to an alternative type of thinking, including robust debate with other jurors during deliberation. Knowledge of systemic racism or the shortcomings of police does not invalidate a juror's need to participate in this process. In fact, during periods of institutional change, it may be even more important for assembled jurors to articulate the many factors that should go into rendering a verdict and which must be considered via phronetic judgment, so that the desire to correct past errors does not overshadow a commitment to other ideals of a fair trial. To understand the Chauvin case as a departure from past practices of both judges and attorneys, it is useful to consider the case of Krishala Reid, who wrote, "I support Black Lives Matter" on her jury questionnaire form in 2016. She'd been called for jury duty in a California county for a murder trial involving 3 Black defendants who were on trial for murdering a white couple in 2012. During voir dire, Reid's statement prompted the prosecutor to ask whether or not she supported the destruction of property as a political act. Reid said she did not. The judge allowed her to proceed as a qualified juror, but the prosecution later used one of their strikes to remove her, leaving 2 Black jurors in the pool. Reid told the Marshall Project, I felt targeted. It was a life-changing experience for me, and I still talk about it to this day. I tell my kids about it, not to scare them, but to make them aware. Her comment indicates that her removal from jury service was not only a disadvantage for the defendants, but also an affront to her sense of citizenship. She felt especially estranged from the legal process because she sensed that her dismissal was racially motivated. In explaining why she did not believe Reid's dismissal to be based on racial discrimination, the trial court judge in her case said that she had, quote, read up on Black Lives Matter and expressed concern about whether involvement in such a group could be seen as consistent with the expectations of conduct from a fair juror. The juror said, quote, going to the Bay Bridge and locking arms and stopping traffic and going down to downtown Oakland and, organizing when they don't have a permit, if that's supported by the person, it gives cause to question whether or not they're going to support our system here. It's disobeying the law, end quote. That the judge held such a perspective on Black Lives Matter, equating it with an unwillingness to follow the law, already created a disadvantage for Reid's qualifications as a juror, even though she was not dismissed for cause. While the trial court judge denied the Batson challenge and found the dismissal of Reid to be acceptable in the case, in September of 2021, the California Court of Appeals reversed the lower court's decision and found that Reid's dismissal was invalid because it appeared to be based on race. The appeals court found that the defendant had been denied an adequate jury in that case. In jury selection for the Chauvin trial, Judge Peter Cahill dismissed jurors for cause during voir dire for a range of reasons: unfamiliarity with English, unfamiliarity with the American legal system, and fear of the consequences that may befall the juror or her family after the verdict. The issue that was the most pressing, because of the widespread familiarity with the video and the protest that followed, was a presumption of guilt for Derek Chauvin, the defendant. While many jurors wrote on their questionnaire that they had a negative impression of Derek Chauvin, Judge Cahill saw it as his primary task to determine what such a negative impression meant and whether the potential juror could take on the responsibilities of a fair trial. While he was sympathetic to critiques of the criminal legal system, he dismissed jurors for cause who said they wanted to serve, but they could not see themselves ever finding Chauvin not guilty. I turn now to two jurors who were seated in the Chauvin case and one who was struck by the defense to offer insight into the way that voir dire was successfully conducted, such that juror positions that were critical of law enforcement and attuned to dynamics of racial discrimination were allowed to be expressed, while at the same time preserving the standard of impartiality necessary for a fair trial. Juror 44, a white woman in her 50s, initially indicated some distance from the racially charged events that followed Floyd's death on May 25th, 2020, when she said that she did not have all the facts of the case and that she had sympathy for all those involved, including the police officers whose lives were forever changed. She drew upon her working life and professional experiences to say that she has seen how, quote, minorities are treated. She goes on to say, laws were created many, many years ago that have not kept up with society and cultural changes. And so, does there need to be changes? Absolutely. I mean, we're talking laws that were made many, many years ago. When asked about her favorable assessment of Black Lives Matter, she gave a careful answer on her questionnaire, writing, excessive force against Blacks must stop, but not everyone working in the system is bad. Then the defense attorney asked her to clarify the statement, and she used the opportunity to elaborate on a conversation she had with a Black colleague who she considered to be a friend. She recalled how her friend explained white privilege to her, saying, and she explained to me where her son, who's the same age as my oldest, the two of them could be in the same community, driving the exact same car, abiding by all the rules of the road. But my white son, if he gets pulled over, doesn't have to fear putting his hands on the steering wheel where the police can see them and not moving until the police tell them to get your registration or get your driver's license. Whereas her son, she's taught them this growing up. This is what you do if you get pulled over by the police. And that was not something I ever thought about teaching my son, end quote. This was a remarkable moment during voir dire because it felt like a reflection of the micro interactions and conversations white Minnesotans may have had in the aftermath of George Floyd's death. There are moments when white people who had not previously felt the urgency of questions of police violence were open to having their minds changed or expanded in relation to the realities of Black life at the hands of law enforcement. The statements during voir dire show a robust belief in the racial inequality that permeates policing and the criminal legal system, a position that must have been at least a little troubling for the defense, but they did not exercise a peremptory strike against her. She was seated. In another example, Juror 52, a Black man in his 30s who coaches youth sports and works in the banking industry, was pushed by defense attorney Eric Nelson on whether he would be able to apply the law even if he disagreed with it. He said yes. He also wrote in his questionnaire about an incident in downtown Minneapolis where he saw the police using mace on a suspect and body slamming this suspect who was not following orders from the police quickly enough. Juror 52 also said he strongly disagreed with the statement that discrimination is not as bad as the media makes it out to be. Juror 52 said, I think it's well beyond what the media can even report. From his statements on the questionnaire and in person, it became clear that Juror 52 took the reality of discrimination as an urgent issue and was also committed to following the expectations of a fair trial. He was seated as a juror. Yet there were still some jurors who, in my opinion, should have been seated, but were struck via peremptory strikes. The most notable example is Juror 76. Juror 76, a Black man in his 30s, described himself as a quiet person who likes watching basketball, who had mixed feelings about being on the jury. He saw it as a weighty responsibility, but also as an opportunity to understand what contributes to the verdict. Yet Juror 76 also spoke candidly about Floyd's death as a pattern of police violence. As he said, quote, you see a lot of Black people get killed and no one is held accountable for it. And you wonder what was the decision? And so with this, maybe I'll be in the room to know why. End of quote. Defense attorney Eric Nelson also brought up the issue of Juror 76's previous experiences with the police when he was living in the neighborhood close to the Cup Foods where George Floyd was killed. Juror 76 said, and so on numerous occasions, if someone in the area died or someone went to jail, it was known for the police to ride through the neighborhood with Another One Bites the Dust playing on the squad car. They antagonized us in the area. After he said this, Nelson mounted a challenge for cause. The challenge was denied by the judge, who said that although there were negative experiences with the police and a strong reaction to Floyd's death, Judge Cahill found what Juror 76 was saying to certainly be an honest opinion, widely held by many people. He later praised the juror for being very introspective about his beliefs, including his belief about whether he could follow the law in this case. All this persuaded the judge that Juror 76 was qualified, but that the defense could utilize a strike in this case because of the specific statements he made about interactions with the Minneapolis Police Department. Considering these three jurors together, we see how despite the judge's efforts at expanding what impartiality looks like to include systemic critiques of law enforcement, it was still not enough to prevent a peremptory strike against a Black juror who was eager to serve, understood what fairness would entail, and whose life experiences would have been valuable for the world-building task that would take place in the jury room. Juror 76's dismissal is emblematic of the ongoing barriers for Black jurors to be seated. At the same time, Judge Cahill created an atmosphere that was largely encouraging of honest critiques of law enforcement alongside opportunities for jurors to affirm their commitment to the standards of a fair trial. I argue he was preparing them to consider a variety of factors in the frenetic judgment that would be central to their task during deliberation. He did this through the way he gave each juror an opportunity to talk about the reactions to Floyd's death and then reflect on their legal obligations as a juror. Due to the judge's encompassing standard for impartiality, Black and non-Black jurors seemed comfortable enumerating the many ills of the current system, and this openness made it harder for individual jurors to be singled out as threatening in their views. In addition to the tone struck by the judge, the new model of impartiality I'm suggesting could be scaffolded by the following processes. First, there should be an articulated commitment by the judge and attorneys to seat a racially diverse jury. Second, there should be a commitment by the judge and attorneys to ask jurors roughly the same number and type of questions. As we saw with Juror 76, asking many more questions from a Black juror improves the odds that he will be struck from the jury pool. And third, more public discussion of how jurors have the ability to separate the pattern of racial discrimination from the particular case at hand is necessary. Judges believe that they are able to do this, separating the pattern from the particular, and they should extend this opportunity to jurors as well. As time passes and support for Black Lives Matter seems to be returning to lower levels similar to the period before Floyd's death, the protests of 2020 and the political context for the Chauvin trial may seem like an anomaly. Yet what jury selection in that trial showed was that the bell has been rung about systemic and persistent patterns of racial discrimination within the law and in everyday public interactions. Jurors of all backgrounds have begun to see how legal judgment must include an awareness of racial dynamics in contemporary life, and they should continue to speak about it during the jury selection process to allow a new model of impartiality to emerge. two things may be true. There is a legacy of racism and policing in this country that must end, but at the same time, every defendant deserves a fair trial with all the protections of the law. The bell cannot be unrung. Thank you very much.
Thank you so much, Sonali, for that really rich and thought-provoking and compelling talk. So many ideas to think about and to take away. Thank you so much. So as a reminder, please, anyone in the audience, you can ask questions in the Q&A, and we're really eager for your questions. So please don't be shy, especially students who are here. I know there are quite a few of you in attendance, but I'll start us off with a couple of questions and then turn it over. So the first question kind of connected to the development of this new model of impartiality, which I find, like I said, quite compelling. It was very helpful to see the distinctions between the way jurors were treated in the Chauvin trial from how juror Reid was treated in an earlier trial. And I was interested, if we kind of go further back, compare really high profile trials, in tracing these changes in how critiques of law enforcement and how discussions of systemic racism have been treated in the jury process. Do you have a sense of how the experience for jurors in the trial of George Floyd, or the trial for George Floyd's murder, changed from the experience for jurors in the trial in the assault on Rodney King in 1992, the trial in 1992?
Yeah, well, thank you for that question. That's been on my mind because this is the 30th anniversary of the jury verdict that led to riots in the uprising in LA that happened in 1992. And in that case, there were so many decisions that made it go in a very different direction than what happened with the Chauvin trial. First, that trial was moved outside of LA. It was moved to Simi Valley, a suburb of LA, which was known to be popular with law enforcement, with a suburban community with far fewer numbers of people of color. That jury had no Black jurors on it. And so that was the first decision that kind of pulled it away from kind of a reckoning with what was happening in that place at that time. And I've looked at the jury questionnaire for the Rodney King trial, and there were very few questions about race. One of the questions was, it sort of described, this is a case of 3 white officers and 1 Hispanic officer being charged with beating a Black man. Does anything about this situation concern you? Was one of the questions. And so just by phrasing it that way, it made it seem like the court wasn't suggesting that this was part of a pattern, or that but it was sort of asking you, like, is there anything particular to you that would make it difficult for you to serve on this case? Another question on the Rodney King questionnaire was, do you have any racial prejudice? Do you or any of your friends have any racial prejudices? If yes, please describe. And so again, it made it seem that the thing that needed to be weeded out were individual prejudices, and there wasn't the sense that that understandings of larger types of societal prejudices or the prejudices of law enforcement were important to engage with. And I think it really was this idea that because in its ideal form, the law is supposed to be colorblind, that we are looking for jurors to speak in that way. But I think with an understanding of how implicit bias works, as well as an understanding of the sociological and empirical dimensions of racial discrimination in the US, that isn't right now the best way to think about what jurors do. They should not bring their own prejudices into deliberation, but that doesn't mean avoiding talking about the racial dynamics in a case. And so I think the part of this change to a new model of impartiality means greater comfort in bringing up sort of patterns of racial discrimination, racial dynamics, and also encouraging people to engage with with examining their own biases and prejudices. In my book, I talk about the idea of turning reasonable doubt inward as something that we should do as jurors, and that we should always be skeptical of our own prejudices when we are jurors, and this goes kind of across the board, even to people who consider themselves, very attuned to questions of racial discrimination, that we all have something to learn when we become jurors, to take a step back from the kind of shortcuts in our own thinking.
That's really interesting. Thank you so much. And yeah, it raises these questions that I know you've written about as well, about what it means to have a jury of one's peers, the distinction between in the King trial being moved out of the immediate area, whereas it stayed in downtown Minneapolis. It's really interesting. If you wanted to say anything about that question of if there's also a shift in what it means to have a jury of one's peers.
Well, I think it is especially interesting with a police officer on trial, because someone you could say, should there have, in some ways, should he have had more police officers at his jury, right? Those were his peers, right? So yeah, the language of peerhood is actually not in the constitutional protections to a jury. It goes further back. It goes back to the Magna Carta, the kind of the first instance of setting up a jury, and so I think that this idea. So with the Chauvin case, it was really, we were looking for peers of the victim, essentially, or people who lived in that area, and I've written also about. While demographic similarities to people who live in a certain area are important in a jury, and racial representation is very important on a jury, another key part of being a peer is understanding the rights that a defendant has. That part of the reason we have juries is so that it can't be this kind of quick case of a prosecution bringing a charge, a judge finding someone guilty, and someone being punished. Like we need to slow down the process by bringing ordinary people in, a random group of people who it's much harder to corrupt than one person, and whose livelihoods are not tied to the outcome. So I think this issue of standing with the defendant is also more complicated when you have a police officer as the defendant in a case.
Great, thank you. Okay, so I'll ask one more question before turning it over. We're acquiring a really interesting set of questions, but I just wanted to ask about something that is, I think, connected to the talk today, but a little bit further, and because I know it's something that you've written about, which is the topic of jury nullification, which is always a kind of fun and controversial topic, certain kind of fun. And so I just wanted to get your perspective on that controversial issue. And so to put that in the form of a question, in your view, should jurors have the right to return an acquittal verdict in cases where they think the law is unjust, thereby nullifying the law? And then I suppose also more, because they in a way have this right, whether or not they should be informed of this right during the jury instruction process.
So first, I will say that, thankfully, no one was talking about nullification with the Chauvin trial, right? That might have been a strategy, right? To say, even if there's evidence against Chauvin, come back with a not guilty. So I think that is also a good thing that was not the way that went. But yes, the power of the jury comes from the jury always being able to return a not guilty verdict if they think that is appropriate. And the judge might disagree with it, the attorneys might disagree with it, even the evidence might, suggest otherwise. But that power that a jury has is very important, and it's kind of it's the crux of what the role of the jury. And I should just note that nullification doesn't cut both ways. You can't convict someone because you really think that they did it. You can only acquit someone if the jury wants to show compassion in a particular case, or they think that the law itself is unjust, or they think the prosecution is corrupt in some way. But you can never use it to put away someone you think is close to guilty, but it hasn't been proved yet. So I do think that there should be more discussion of nullification, but since it's so powerful and can be misused, one of the most notable ways in which nullification has been misused is in lynching cases in the South during the Jim Crow era, that white juries refused to convict defendants who, almost certainly, engage in acts of lynching because they didn't want to punish the person for it. So we see that, like, that in terms of racial injustice, like, jury nullification has been a part of that story. And so so I know that there's some people who don't want to expand the discussion of it for that reason. That's kind of like, we have enough other problems. Why go telling people about jury nullification? But and so what I think we need is just more thoughtful discussion about it prior to jurors showing up in the courtroom. Like, the first time you hear about jury nullification shouldn't be when you're Googling, like, I have jury duty tomorrow, what do I need to know? Because, like, that doesn't give you enough time to really think about what is this power of nullification? How can it be misused? What should I think about? And what does it mean to use it in a prejudicial fashion? What does it mean to use it in a different way? And so that's why I think that, like, more expansive civic education about what it means to be a juror is necessary if we want jurors to exercise their full capacity. And I call my book Radical Enfranchisement, because I think that actually seeing the power that jurors have in the courtroom creates a different relationship between citizens and the law than what we usually understand. If we really see ourselves as enfranchised as jurors, we see that we are the kind of facilitators of the law, but we're also the ones who decide when to disobey laws that we don't agree with, or nullify laws that we don't agree with. And so there's a potency to the power of the juror that I don't think we've fully appreciated, and nullification is part of that. But we kind of need to start earlier and do it more often and talk about it more often than just the moment of jury duty.
Thank you very much for that. And that actually, I'll now segue into the questions from the audience. And the first question is connected. So this is a question from Riley. And they ask, if more courts were to adopt a new model of impartiality like the one you've outlined, do you think that that would have an effect on the lives of people who serve on juries, even outside of the jury room?
Yeah, that's my hope, that I think this model of impartiality, where you realize you can hold two things at the same time, and feel very passionately about, let's say, like, problems of police violence in this country, but also feel like it's, that doesn't mean people should automatically be found guilty, or that you don't need to follow the rules of the trial. I think that kind of balancing would be really useful outside of the courtroom as well, and in political conversations, in people like kind of rethinking their own political commitments. I also just think it's trusting to people to be more sophisticated thinkers than we generally give them credit for. I think part of people who are skeptical about juries are kind of like, I'd never want to have 12 random people deciding on my fate. Like, I don't have that much faith in in Americans, and we can talk about why people feel that way, but I think this model of impartiality that I think Judge Cahill was putting forward there, and that I'm building on, actually trust people to be kind of complex people who can hold different ideals at the same time, and take their work as a juror seriously, also take their role as a citizen, as an activist, also seriously. But I think being a juror is a type of code switching that we all do, and that's not a bad thing. Like, I think it can be ennobling. It can be it's necessary to do that kind of work, and so my hope is that if we think about impartiality in the juror context in this way, we'll also see that there might be other places in political life where we can also hold two things true at the same time.
Great, thank you. Okay, since there are quite a few questions, I'll move to the next one. So Kevin asks, he knows that racial inequalities in the legal system are relevant in less intense cases, as well as these high stakes, highly publicized cases. And the question is, do you see these changes in terms of how judges view impartiality also happening in these cases, the lower stakes, less public cases, where inherent biases are probably relevant but are less obvious?
You know, that question kind of dovetails with research that I've seen that shows that it's actually in cases where race doesn't seem to be salient that we see jurors making more kind of racially loaded statements in deliberations. So so Kevin is exactly onto something. So so what I would like to see is just more open discussion during jury selection in all types of cases. You know, even the more mundane ones where it doesn't seem to be immediately relevant. And I think some judges do provide an instruction about implicit bias to their juries, both during jury selection and then at the jury charge right before the jury deliberates. And I think that's another place to ask jurors to think about all the different ways that bias might come in, and what we know is that one. When there is a more racially diverse jury, even the comments that white jurors make seem more attuned to race. Some people we might say like, oh, you're really relying on Black jurors to bring up all of these issues, but what research has shown is that actually just even the presence of a racially diverse jury, even if those jurors of color don't say anything, leads to more active deliberation, a more consideration of different factors, longer deliberation times than when you have all white juries, so I think it's the role of the judge is to to slow the process down through bringing attention to implicit bias, to bringing attention to racial dynamics, even in a case where it might not seem to be the most important thing.
Excellent. Okay, thank you. All right, so we have a couple of questions that are connected. So Love asks, you mentioned that the judge's efforts to set a standard of impartiality weren't enough in the case of juror 76 because the juror was removed by a preemptive strike. And so they ask, what sorts of checks and balances do you think would be most helpful in setting up a fair jury in terms of all the actors involved, judge, defense, prosecution? What do you think is our best case scenario going forward? And I'll just put a couple of related questions with that. So Love's question about checks and balances, and then Seth asks, would the new model of impartiality entail any procedural changes or innovations? Should there be some attempt to formalize this? And then I suppose, just give you one more question more broadly, Giant, and my apologies if I'm mispronouncing anyone's name, they ask, is there any way for the peremptory strike to be a fair method of exclusion at all, or is it antiquated in view of the perspective you've outlined?
So all of these questions are very hot topics right now for legal scholars. So I have written on the value of doing away with peremptory strikes altogether, and I take this point from Justice Thurgood Marshall, who back when Batson was decided realized like this is not going to do it. Like just having people say that the attorney was being discriminatory and then having the judge decide. Justice Marshall knew that attorneys might be acting in a racially discriminatory way that was opaque even to themselves. So like, of course, the judge was not going to say that they were being purposely discriminatory because they wouldn't see it that way. But Justice Marshall knew that that would be at play. And so he thought that anytime we have peremptory strikes, we are open to discrimination, and there's really no way of getting around that. And as I said, I'm sympathetic to that position, but watching the Chauvin trial and seeing what happened there, it made me think like this might be another path, which is kind of changing the culture of the courthouse. Such that both sides are very careful in their use of peremptory strikes, and in the Chauvin trial, both sides left strikes on the table. That is, they had strikes remaining at the end of jury selection, and so that showed that they showed some restraint in that way. So So this problem of peremptory strikes has led some states to make a procedural change. This was, the first state to do this was Washington State, where it said that instead of using the Batson method of adjudication, the judge would decide whether an objective observer would think that the strike was racially motivated. That and kind of the judge would say that since we want to have a racially diverse jury, it doesn't matter whether you tell me that you remove that Black juror because they worked at the same store that the defendant's sister worked at. What it looks like is that you're picking off Black jurors, and we can't have that. So it takes it away from the intent to kind of what is the outcome. And so I think that is an important procedural change. California has followed, Connecticut has followed. So we're seeing other states trying to change the way that claims of racial discrimination are adjudicated to get more racially diverse juries. So I think that's one way to institutionalize this. Another thing that that would be helpful is to basically have there be so many Black jurors in the pool that you can't do it with all of them. You have more Black jurors than you have strikes, and so that's also this idea of like changing the whole makeup of who shows up for jury duty and who speaks openly about critiques of law enforcement and racial discrimination actually changes the calculations that that you can, like the number of peremptory strikes is just not enough to clear it. And that's why I think that those numbers of not like 55% of Americans who said they supported Black Lives Matter in 2020 is really important, because it's only when you get those kind of big numbers across the board that there might be a change in what is allowed to be said during jury selection.
Great, thank you. Okay, here's a question from Ian, that a somewhat more philosophical question. So the question, I'm going to paraphrase, is whether or not in charting these changes about ideas of impartiality, whether or not the idea of impartiality has changed, or if that has remained the same while what has changed is views about our understanding of what views are consistent with being impartial, i.e., you can now voice support for BLM and be recognized to be an impartial juror, or if the idea of impartiality has shifted. What do you think?
I would say a little of both. That I think that there's a way in which, just even in the language of the Constitution, like a fair and impartial jury, right? That the fact that like fair and impartial kind of come together, it makes it seem like both of these concepts are intuitive concepts. And like we, even like studies have shown that like children as young as like 3 understand that like if you have 10 things, you shouldn't give 9 to one child and 1 to the other. Like that's not fair, So we have intrinsic understandings of fairness. And so by saying fair and impartial, it's making it sound like impartiality is also intrinsic. That like there is a way that it's kind of like almost like a Platonic concept that we can that people understand and you can kind of grok, and it makes sense to everyone. And what I think has shifted is an understanding of impartiality is contextual and constructed. That impartiality in different realms means different things, and actually being more explicit about what impartiality means as a juror, allows for support of BLM to fit within it. Whereas when you just said, it just exists out there and you either have it or you don't, it places it in a different category. And the students of political theory out there know that a lot of political theory just centers on the idea of what does it mean to be reasonable, right? And what is objective, what is reasonable, what is the man on the Clapham omnibus, used to be the a standard of the Joe Schmo, what does that guy think, and so we have all these different ways of getting at what does it mean to be fair or to be reasonable, and I actually think that given the kind of complexity of patterns in contemporary life, especially around race, that we need just more details of what impartiality as a juror means. And so by defining it more, we're actually expanding the number of people who can fit within it.
Wonderful, thank you. Oh, that's very helpful. Okay, so we are we only have a few minutes left, and unfortunately the time's going by quickly. So I'm going to try to fit in a few more questions. So to take two of the questions together, one from Reg and again, sorry about if I'm mispronouncing names, and Amy, they both ask about the fact that Chauvin yesterday filed an appeal, or that wasn't Amy, I've got Emily, I'm sorry. So they're both asking about what you make of the fact that Chauvin has filed this appeal, and I think, a bit of a prognostication request, what you think.
Right. Yeah, no, I'm following the appeal with great interest, and it almost felt like we saw this appeal coming from day one, because Eric Nelson, the defense attorney, said, "I want the trial moved." Like how is my client going to get a fair trial in the middle of Minneapolis? And then he said, "If you're not going to move it, I want them sequestered. Like keep them in a hotel. Don't let them go home every night." And the judge said, "I don't." The judge knows that sequestration is just a huge emotional and mental strain on people, and so he didn't want to do that. They were sequestered for deliberation right at the end, but throughout the 3-week trial, they went home and came back. So it just felt like, he was that the defense attorney was going to use these things on an appeal. So I think it was expected that this would happen. That oftentimes in high-profile cases, it's the jury selection process that's used as the basis for the appeal. But what we found is that higher courts oftentimes defer to the trial court judge with jury selection. That there's so much discretion required in jury selection, and the judge really has to kind of determine, like, are you credible? Are you telling the truth? Are you answering in a candid way? Are you higher courts don't really want to second guess trial court judges on that. So if it goes in that direction, and a higher court would say, like they understand that, Chauvin's team, wanted something else to happen, but it doesn't, rise to the level of mistrial. But on the other hand, if a higher court is sympathetic to, like, because of the like kind of just global nature of the video of George Floyd's death, that there should have been more precautions taken to have get a fair jury, then it could go in his favor. People more well versed in appellate decisions than I have said that they don't think it will be reversed on appeals.
Thank you. All right, so then I will give the last question here to Amy, and those of you who have asked more questions, I've made sure to save them so that Professor Chakravarti will have them and can see them afterwards. So thank you, Ari, Julia, Sachin, Brian, for asking questions that we won't be able to get to. But Amy asks, given the new standard of impartiality demonstrated in the Chauvin case, do you think that juries will serve as an institution for advancing social change and the larger push for racial equity?
I would like that. I don't think they can be the center of it, because it's, juries by their nature are one-off decisions. It's just case by case, and then you should never go into a case saying, like, I want this to further a social justice cause. You can't, that doesn't make for a good trial and a fair trial. But I want it to be seen as a place where Americans take seriously their responsibilities around punishment, and so I think by seeing that there are these possibilities to kind of bring in what you know about the world around you and take seriously what the court is asking of you, that we will see change from juries. But mainly what I hope is that people will develop a desire to serve on juries, and because it's much easier to be seated on a jury when you actually want to do that, and you answer questions differently, and just the whole process goes differently when there's willingness. So I'd like to see that happen, and I guess I'd also like to see kind of people from all parts of the political spectrum being willing to kind of set aside some of those beliefs so that they can hold the responsibility of the juror, but not set aside all of them. I read that a defense attorney was frustrated that so many young people were coming in and just voicing these very strident critiques of the police and of law enforcement and the legal system, that they would have been good jurors, but they wanted to kind of make a statement as part of the jury process rather than engage with the process. And so I would say, to people to hopefully don't fall into that trap, that don't use jury service as your kind of soapbox, like that, that it's a different role and it's an important role. And we need more different types of people to do it.
Fantastic. Thank you so much. If we were all in person, I'd give you I'm sure we would all be giving you a very warm round of applause. Thank you so much for this really engaging and stimulating question, which you can tell there were a lot of people here today, even on a very sunny day in springtime in Hanover, which, we have to treat them as very special, and all these really great questions. And I know that, for me, I tend to think of the best sign of a really excellent talk is whether or not I'll keep thinking about the ideas and if they've also shifted my own thinking on things. And that's very much true in this case. So thank you. Thank you so much. We really appreciate it. So before I turn it off here, and I wanted to just announce the next event, which is also connected to the law. So a lot of people here today are interested in the law, which is the Stephen R. Volk lecture, which is on Monday, this coming Monday at 5 p.m. And Judge Beth Robinson will be speaking on courts, myths, and the foundation of liberty, exploring misperceptions about judging and the threat to our independent judiciary. So I'm sure that will also be a great event. But today, importantly, I just want to thank you so much for the really fantastic talk. That was really excellent. Thank you so much.
Thank you. It was really fun.